I'm Rob Sterne, founding director of intellectual property law firm Sterne, Kessler, Goldstein Fox. Today, I want to talk to you about a critical topic in the current patent office litigation landscape: claim construction in post-grant proceedings after the American Invents Act. Claim construction is a critical aspect of the new contested proceedings: the inter-party review, the covered business method review, and the future post-grant review. Claim construction must be proposed by the petitioner in the petition and responded to by the patent owner in the patent owner preliminary response if one is filed. At that point, the board, when it institutes the trial of the case, of the proceeding, issues its own claim construction that will be utilized throughout the trial, that is required to be completed within 1 year after the trial is instituted. Now, the claim construction rule that is used in the new post-grant proceedings is the same that is used in original prosecution, which is called the broadest reasonable interpretation of the claims in light of the specification at the time of the filing of the case. Now, this claim construction rule, referred often to as BRI, is in contrast in many cases to the claim construction done in parallel litigation, whether it be in the district courts or the United States International Trade Commission. Both of those tribunals, in contrast, use the Markman claim construction, which oftentimes is narrower than the BRI that is adopted for the very same claim terms involving the very same patent in this proceeding in the PTO. Now, patent owners are extremely dissatisfied with these two different claim construction rules. They feel that they are being whipsawed by the process, and many believe that this is correct. And many large owners of patent portfolios, as well as individual inventors and universities, have jumped on the bandwagon saying that there should be uniformity between the claim construction rules used at the patent office and the claim construction rules used in the courts and the ITC to enforce the very same patent right. The reason that their argument has a lot of merit is because validity and infringement traditionally in enforcement proceedings requires the same claim construction rules to be used in each proceeding. And proponents of having a unified rule argue, why should there be a different validity standard for claim construction in the PTO than in the enforcement proceedings? My prediction is that this is going to continue to be a very hot button issue in the post-grant proceeding landscape as patent office litigation becomes an integral part in all enforcement of patents in the United States. And I think it's also fair to say that there is a likelihood that in the future we will have a unified claim construction rule that will be the same as the rule used in the courts and in the PTO. Thank you very much.